I know there's certain cops that are actually more as like mentors instead of like enforcing the law. Like I know a lot of cops that like if kids do certain bad things, they don't necessarily book them in jail because they know like this is probably their first time, so they're probably giving advice or try to keep them from doing it next time. Like they'll give them a warning or something and then let them go.
The oldest is 14, the youngest 9. All 3 could be in juvenile detention until their 18th birthday.
And it's all because they refused to spend time with their father after a judge ruled he could be part of their lives.
It might sound like a staggering number. 45 kids under 10 years old were arrested in Colombia last year.
Fix a disturbing trend. Too many kids being locked up for minor offenses.
Meanwhile, a detailed 2-year report just released from the U.S. Department of Justice on juvenile cases in St. Louis County says the courts are racially biased, putting more blacks in the system.
Do we really think it makes sense to lock so many people alone in tiny cells for 23 hours a day, for months, sometimes for years at a time? That is not going to make us safer.
In 2014, law enforcement officers from around Missouri made over 250,000 arrests. Just over 8.5% of these arrests were youth under the age of 18. Nationally, Missouri ranked 14th for highest number of arrests of youth.
Children, youth, and teens also experience high levels of victimization. In 2011, over 69% of teens ages 14 to 17 years old nationwide experienced some form of physical assault in their lifetime. Over 56% experienced property crime, over 41% experienced abuse or neglect, and over 27% experienced some form of sexual victimization.
How do police officers impact youth? Well, we account for over half of the referrals made to the juvenile office. In 2014, we account for over 23,000 referrals to the juvenile office statewide. That means that I'm going to spend approximately 25% of my time with youth. I have found that it is important that when dealing with youth, that we always use best practices.
To best serve youth and their families, you must first understand your role in the juvenile justice system. As law enforcement officers, you operate under applicable law. Criminal charge codes are the same for juveniles as they are for adults. However, it's important to be familiar with the juvenile code for the state of Missouri. It can be found in chapters 210 and 211 of the revised Missouri statutes. Some of you may be asking yourself, why are the juvenile and adult systems so different? Well, the juvenile court system is restorative, designed to rehabilitate young offenders and help them transition into a viable asset in the community.
There are 3 different referrals to the juvenile office. 1, juvenile delinquency. 2, status. 3, abuse and neglect.
Many times youth may commit what's called a delinquency act, which by statute is considered a criminal act. And then they also have what are called status offenses. So those are things that are illegal for children to do just based off of their status as a juvenile or not being an adult. So skipping school, running away from home, incorrigibility or refusal to follow directives at home. Those are things that we many times see as an issue that needs to be treated, but doesn't necessarily mean they need to be maybe arrested for or taken into detention for.
Knowing the differences between these offenses are critical because of the numerous factors in handling each offense. Over the next few minutes, we will break down some of these factors. The age of a child is a critical element in determining whether a matter is subject to the jurisdiction of the juvenile court. Generally, in cases of delinquency or status offenses, the juvenile court has jurisdiction of a child until his or her 17th birthday. Keep in mind, the applicable age in these cases is the age at which the alleged offense was committed. In abuse and neglect cases, the juvenile court has jurisdiction of the juvenile until the juvenile reaches his or her 21st birthday. The location where juvenile juvenile matters are held vary from case to case. Ask yourself, does the juvenile reside here? Was the juvenile found here? Was the offense committed here? Your answers to these questions determine whether or not your county's juvenile office has jurisdiction. Regardless, your jurisdiction's juvenile office must be contacted. It's important to relay your findings to these questions to the responding juvenile officer.
Now that you've taken the juvenile into custody, you'll need to make sure you get his pedigree information as well as the arrest charges. You'll then need to contact the juvenile office and speak to a juvenile officer who will then use this information to complete the JDTA, which is the Juvenile Detention Assessment Form. The juvenile officer will then decide at that point to release the child to a guardian, and a parent, and/or a suitable adult, or transport the juvenile to a supervised detention center.
This may look different in each jurisdiction. It's important to contact your local juvenile office regarding policy and procedures of presenting a juvenile. If the juvenile is released on scene, you still must complete a report on the incident. The report will go to the juvenile office where it will be screened and processed accordingly. When transporting a juvenile, use all precautions you would for handling an adult. Remember, federal and state laws prohibit juvenile offenders from having sight or sound contact with adult offenders. If the juvenile is alleged to have committed a felony act, or an order from the court for a non-felony act is received requiring fingerprinting or photographing, continue to ensure that the juvenile is separated from adult offenders. You may not interrogate the juvenile prior to having the juvenile officer, the juvenile's parent or guardian, and/or the juvenile's attorney present for questioning. Should you request an interview with the juvenile, you must wait until all parties are present and the juvenile has been read his or her Miranda rights from the juvenile officer or the juvenile officer's designee. When holding a juvenile pending transfer of jurisdiction to the juvenile officer, these guidelines must be followed. A delinquent offender may be placed in a locked holding cell and handcuffed to a stationary object for no more than 6 hours. A status offender cannot be held in a locked holding cell or handcuffed to any stationary object for any amount of time. Status offenders must have a path of free exit from the building. Continuous visual supervision of the juvenile must be maintained. At no time is sight or verbal contact with adult offenders permitted.
Once the juvenile officer arrives, jurisdiction is then transferred to him or her. Depending on the information on the JDTA, the juvenile officer could offer an alternative to detention or authorize the juvenile be transferred to a juvenile detention facility. If this occurs, the juvenile officer will ask the police officer for a probable cause statement, which will be filed with the juvenile court. I don't know about you, but as a police officer, I get pretty frustrated taking the same juveniles into custody on numerous occasions, yet they never score a detention. What is this JDTA form, and how effective is it in reducing recidivism? In the next segment, we'll introduce the Juvenile Detention Alternative Initiative, and we'll break down just how effective this model is. There are several differences between adult and juvenile justice systems. The juvenile justice systems are restorative and focus on rehabilitation.
In 1992, the Annie E. Casey Foundation launched the Juvenile Detention Alternatives Initiative, or JDAI, as a response to the over-reliance on unnecessary and inappropriate detention of youth nationwide.
The JDAI initiative is a product of the Annie E. Casey Foundation and commenced in 1992. And it's based on some values that children who come into the juvenile justice system can be more successful if we treat them in a way that highlights their successes as opposed to their failure. The core strategies here are the two things we are looking for are public safety and better outcomes for youth.
MJJA asked several circuits within Missouri if they would be interested in working with that program. Ultimately, in 2005, we had 4 circuits that said yes, and that was Jackson County, Kansas City, Springfield, Greene County, St. Louis County, and the city of St. Louis.
This is what JDAI looks like today. The last state to come aboard, Georgia. Jim's working in Georgia right now, bringing them aboard. 1 in 4 youth live in a community that participates in JDAI.
As part of the approach, we gather all of the significant players, and that includes community people, in a collaborative effort within the county or the state to examine how, through data, how we are doing with our kids, where the soft spots are in the system that may be counterproductive, and find methodologies to change those programs and policies so that we do provide public safety and we do have better outcomes for our children.
The initiative uses a model rooted in 8 core strategies, which include collaboration between major juvenile justice agencies, government entities, and community organizations, use of accurate data to diagnose the system's problems and identify real solutions, objective admissions criteria and instruments to replace subjective decisions that inappropriately place children in custody, alternatives to detention to increase the options available for arrested youth, case processing reforms to speed up the flow of cases so that youth don't languish in detention, reducing the use for secure confinement for special cases like technical probation violations, deliberate commitment to reducing racial disparities by eliminating biases and ensuring a level playing field, improving conditions of confinement through routine inspections.
A lot of it was looking at low-hanging fruit. What could we do to first address kids in detention? So the state statute allows us to detain based upon public safety, failure to appear, and protection of the child. We started addressing all of the 8 core strategies in a 3-year cycle. At the end of the 3 years, we started looking at the data. And the data was showing that in some of the circuits, they were decreasing their detention population by 50% or more. We were finding that the numbers of referrals and filings of petitions and overall crime for juvenile had also decreased. And over the course of this last 10 years or so, we've actually decreased around 20,000 referrals statewide.
This initiative, which a lot of people were a little leery of, protected the community. And that's where a lot of people were concerned about community safety. The good thing about having all of these states involved, is that you don't have to reinvent the wheel.
The Juvenile Justice Advisory Group stated that yes, this is a proven program and it's something that's desperately needed in Missouri, along with addressing gender and disproportionate contact of youth, that this could help with both, as well as look at our kids in detention. And so funding was provided for the coordinator at that point. So different changes of funding allowed us to continue the replication of the programming. So now we're replicating as a state, not just necessarily individual sites, although we want to continue to address where kids are detained. And so all of our detention circuits are addressed first, but we do have a couple of circuits, Cape Girardeau and Joplin, as 2 sites that do not have a detention facility. And we're replicating JDAI there to determine if it's something that is practical for everywhere in the state.
Missouri has become one of the best models in the country for state expansion of JDI philosophy.
We do have other states that have come here to Missouri, Iowa, Kansas, South Dakota, North Dakota, Minnesota, New Jersey, Illinois, have all come to Missouri to actually look and see what we're doing here and how does it work, because it does seem to be working and having a positive effect within juvenile justice.
One of the reasons it has been so successful has been the buy-in from the various stakeholders along the way. In particular, from law enforcement, I think it's important that law enforcement take a key role in this because you are the first line on the streets, working with kids, working with our citizens, and you should understand as much about this as you possibly can to not only explain it to your constituency that you work with, but to understand the process and why we are doing what we're doing to achieve the goals we're looking for.
These strategies have been proven to reduce unnecessary and inappropriate secure detention, reduce costs, increase system fairness, and improve the juvenile justice system overall without compromising public safety. The Juvenile Detention Assessment is one tool developed to assist not only JDAI sites, but all Missouri courts due to the implementation of Court Operating Rule 28 on January 1, 2012. It provides objective criteria for evaluating the need to securely detain youth due to risk to public safety or failure to appear in court. Using this tool, the juvenile office is able to make an objective conclusion as to whether or not the juvenile should be released to a parent, a guardian, or another suitable adult, participate in an alternative to detention, or be detained at a detention facility. Examples of alternatives to detention include a conditional release, evening reporting center, GPS and electronic monitoring, shelter care. With the growth of JDAI sites and tools, Missouri has seen a decrease in several areas related to youth detention.
You may be asking yourself, what about recidivism? Are these kids getting off easy with a decrease in detention?
Not at all. In 2015, 4.7% of juvenile offenders failed to appear for court. That's less than 2005. And as for the recidivism, since Missouri's replication of JDAI, the recidivism rate for juvenile offenders has dropped to 16%. JDAI is a process, not a conventional program, but it's a process that is headed in the right direction.
Like when I'm driving or something, I mean, I'm kind of paranoid, because my skin color, sometimes I don't feel like black people aren't treated as fair.
In 2015, 47% of youths admitted into a detention facility were black. In certain counties, black youths were 6 to 8 times more likely to be referred to a juvenile court.
Black youth receive harsher punishments for similar misbehavior and are more likely to receive school suspensions and expulsions than white youth. So how does Missouri address disproportionate minority contact?
DMC is measured based on referrals, and law enforcement, of course, is going to be the agency that refer most kids to the juvenile justice system, and naturally so. My job is to go into local jurisdiction to look at that data and try to pinpoint where some of the disproportionality is coming from, and work with those local jurisdictions to come up with strategies based on that data.
The cops that we have, in this generation, they take oaths, to protect and serve, and that goes for everybody, all races, And the ones that take it past that for their own personal endeavors, I feel that those are the cops that we really just don't need around. And the fact that they're doing that is making all cops look bad, and that's just not the case. So,
based on the Juvenile Justice Delinquency Prevention Act, which is a federal mandate that all states must work on the DMC issue. And so this is not a local issue. This is really coming from a federal mandate based on that act. And this has been around since the early 1980s that states must work on the DMC issue. My role as state coordinator for the DMC is to try to work with law enforcement agency on the effective ways to interact with youth in general, not just youth of color. And so we really try to work with those different law enforcement agencies to identify different strategies that those officers can use without having to make an arrest. We talk about their discretion, as they are the gatekeepers of referrals coming to the juvenile justice system. Are they able to have discretion in determining when to make an arrest, at what point to make an arrest? Can they do other options outside of making an arrest?
We know from research that's been done over the years, and as we've transitioned to a JDAI site, how important it is to really try, if we can, to keep kids in the community. With law enforcement, one of the things we recognize is that they're usually the first point of contact. They're the first responder to the scene, so they can set the whole tone for how everything goes, that whole situation. That child and that family's perception of not only law enforcement, but the system in general, the court system. It's so important that interaction be as positive as it most possibly can be.
When I teach my training with law enforcement, I typically ask them, what is the role of law enforcement in the juvenile justice system? And a lot of them think of it as just an arrest, but truly what we ask them to do now is to think of how to do their jobs differently. Can they be that person that has that good contact with youth? Can they be that person that look at other means other than arresting youth, look at other resources in their communities?
I'm here doing non-traditional police work, and so I'm a mother, I'm a father, I'm a counselor. I'm gonna take me to the store to get some personal hygiene type things, take me here to pick up my medicine. That's the type of police work that I do. My job here is to build relationships.
Many times kids who have committed an offense, have made a mistake in life, they can be rehabilitated from those things and remain in the community.
If we're going to be effective on making an impact on the DMC issue through law enforcement, again, because they are the gatekeepers of the referrals, they really control a lot of what comes to the juvenile court. I think that we had to look at different strategies and different ways of effectively interacting with youth. Some of the strategies that we really work in regards to the local jurisdictions is de-escalation strategies, mentoring programs for communities, teen courts, resources that work with mental health with kids, their families.
I think they're always here to help us and make us feel safe when we need their help.
In a lot of ways, families are reaching out to law enforcement because there are no other options for those families to make contact with. In a crisis situation, if it's just the arrest and the officers leave it at that arrest, that does not effectively make a change in that child's behavior. The way we do business can't always be, that's how we've always done it. We've got to be able to make changes based on what is happening in our world today and look at trends, look at the data to see how we can effectively make our job work as best we can for those who we encounter.
Go back to why it is that you became an officer. And usually what that is to protect and serve. And obviously you have to protect, but it's also about the service too. It's about servicing the community.
The process after a juvenile is detained is comparable to the adult court process.
An order of detention will be filed with the juvenile court, and a detention hearing will be held within 72 hours from the time detention was authorized by the juvenile officer. A petition will be filed by the juvenile officer's attorney alleging the juvenile's charges and requesting action from the court. Once the juvenile goes to court, a two-part hearing will be held. The adjudication hearing will determine whether the juvenile is adjudicated and under the jurisdiction of the court. If adjudicated, the juvenile will then have a disposition hearing. In some cases, the juvenile court may exhaust all resources that can be provided for a juvenile offender. In those instances, the juvenile court can commit a juvenile to the custody of the Division of Youth Services, or DYS. Juveniles can be committed to DYS until the age of 18. However, in certain circumstances, the committing court may grant a petition by DYS to retain custody of a youth until the age of 21. In 2015, 713 juveniles were committed to DYS, 13% of which were committed for serious felonies. If the juvenile commits any of the following, a hearing will be held to determine whether that juvenile should be transferred to the adult court to allow prosecution under general law. This is referred to as certification. Certification is the last recourse for the juvenile justice system.
Generally since about 2010, our average has been about 130 to 150,000 reports a year. Many kids will tell us, we knew we were in a bad situation. We knew, we don't disagree with being removed, but it's just the way it happened.
Abuse refers to any physical injury, sexual abuse, or emotional abuse inflicted on a child. Neglect refers to the failure to provide education as provided by the law, nutrition, or medical, surgical, or other care necessary for the child's well-being.
We operate a 24-hour hotline to receive any reported concerns of abuse or neglect of any child, and we have the responsibility to investigate those reports. The way those are reported can be by mandated reporters or permissive reporters. Mandated reporters by law is anybody that's working around children or with children or in professions that will bring them in contact with children.
As an officer, I am a mandated reporter, and I have the authority to take emergency protective custody of any juvenile that I have reasonable cause to believe imminent danger may occur before a juvenile officer or court can take protective custody. This is referred to as judicial custody, and it cannot exceed 12 hours.
If emergency protective custody is taken, law enforcement officers must also make reasonable efforts to notify the juvenile's custodian, report the alleged abuse or neglect to the Child Abuse and Neglect Hotline at 1-800-392-3738, complete the Missouri Children's Division Form CS-33, complete a report, and complete a probable cause statement to be filed with the juvenile court.
When reports are called in, it is manned by Children's Services workers, and they take the caller through a structured decision-making process where they go down different pathways depending on what the allegations might be. A lot of states don't have a 24-hour hotline. So we're very proud of our system. We take a lot of reports. We have a hard time staffing our hotline and keeping staff there. It's a hard job to listen to those allegations coming in all day. So we're trying some different things. One of those has been outbasing some of our hotline staff in different offices around the state. That seems to be promising. What we're really proud of, though, is the online system. It is for non-emergency reports only. It is for mandated reporters only. So the intent and the process is, if it's not an emergency, that the mandated reporter would be able to file their online report maybe when they finally sit down at the end of their shift. If the report looks like it's going to lead possibly to a criminal investigation or some kind of felony conviction, that would always go along the investigation track, and that is when we do have responsibility to invite law enforcement to co-investigate that with us.
Law enforcement is investigating a criminal allegation. They are looking for a criminal violation. They don't have to have care, custody, and control. They don't have to have an injury for a criminal violation to have occurred. Children's Division is doing an administrative investigation. Their first role is to ensure safety of a child. Can they leave that household and have either safety plans in place that are voluntary to ensure that child's safety, and if not, they need to contact the juvenile office and request removal. Children's Division cannot remove a child. They do not have the statutory authority. Law enforcement can. If there is imminent danger, they can and should take immediate protective custody.
If a custodian is arrested and the custodian declines to voluntarily place the juvenile with an appropriate temporary placement, the law enforcement officer must take emergency protective custody of the juvenile and contact the Child Abuse and Neglect Hotline and local juvenile office. During transport, the juvenile is not permitted to be restrained. Further, the juvenile is to be held in unsecured location with consistent supervision. This can be a very traumatic time for a child, so it's crucial efforts are made to minimize the trauma. Once the juvenile officer and the Children's Division worker arrive, jurisdiction of the juvenile is transferred to them.
Interviewing a child is the most critical first step. And how we interview children and how many times we interview children, and keeping in mind that just being asked questions is traumatic for a child. And so if you're on the scene and you are the one who is doing the initial interview, it is very important that you take several things into account before you begin the interview. The first is the environment. Are you in the bedroom where the abuse occurred? Are you in the car with the child? Does the child feel like they are the criminal at the point they're in the car? Are you within earshot of the alleged perpetrator? Just taking into account that environment, where is going to be the most comfortable interview for that first initial interview. The second thing to take into an account is to remain calm, both physically and verbally. When children disclose abuse, we're upset for them. They've been hurt. We're angry that somebody has hurt a child. Even if we are as professional as can be, children know. They know by your facial expression, they know by your body language. It is very important that you really remain calm, because if you have a negative reaction, a child will internalize that negative reaction. They will shut down and they will stop. They also very likely know their alleged perpetrator, and they may love who has hurt them. And so your anger towards somebody that they love may also stop them from continuing to disclose. You ask open questions. Tell me more about that. You ask, tell me what happened next. With a child, asking leading questions is an easy way to get that disclosure thrown out and lose charges.
There's a variety of ways that we work with law enforcement, and I just want to stress how important those relationships are in the communities. We really are there for one another. We have workers that will call law enforcement to go out when it is a very serious or scary situation. We want to be cognizant of their time, of your time, and making sure we're asking to go at the appropriate times too. And I would just encourage any law enforcement officer with any questions about what the Children's Division does or what their role is to really reach out to the circuit manager from the Children's Division, the manager or supervisor in those local counties and local communities where they're working together. I think building relationships with one another would be I think is one of the most important things we can do, and share information and communicate. We all have enough to do. And I think everybody, their hearts are in the right place. They want to do the right things for kids, and we just have to make sure we understand your role and you understand ours, and that we're working together on that. And I think that's going to make it better for kids.
My name is Marcia Hazelhorst, and I am the Executive Director of Missouri Juvenile Justice Association. I hope that you found this video informative. Our intent was to provide you with an overview of the guidelines in working with youth in the Missouri juvenile justice system. We recommend that you contact your local juvenile officer for detailed information on certain procedures, as they may vary slightly. I want to take this moment to thank each and every one of you for the work that you do for Missouri's children and families. Your care and protection of Missouri's children is invaluable. I also want to thank the police officers, court staff, and our partners from Children's Division, Office of Child Advocate, Department of Public Safety, and the Juvenile Justice Advisory Group who assisted us in making this video. Finally, a special thanks to Dennis and Brianna Larimer for the countless hours devoted to producing this video. Thank you.
The Missouri Juvenile Justice Association is a statewide, not-for-profit 501 organization whose mission is dedicated to promoting justice for children, youth, and families within Missouri. Funds were made available for this project through the Missouri Department of Public Safety and the Missouri Juvenile Justice Advisory Group from funding provided by the U.S. Department of Justice Office of Juvenile Justice and Delinquency Prevention. A special thanks to the Office of State Courts Administrator for their assistance in this production.
Missouri Juvenile Justice Association, what I really see it as is a support network for many juvenile justice professionals across the state. And that could be not only juvenile officers, but Missouri Division of Youth Service employees, Children's Division employees, other mental health, substance abuse treatment providers, anybody who provides services for at-risk youth. And what I think it does is provides them support not only in education, such as going to the different conferences, educational conferences and seminars that they have each year, but also just providing funding for different initiatives that they want to provide in their circuit, going out to those circuits and providing technical assistance and consultation. I think that those are some of the biggest things that the Missouri Juvenile Justice Association does.